Hi, this is Jen Rubin, editor-in-chief of the Contrarian. I'm very pleased to welcome Rachel Cohen, who until recently was a third-year associate at Skadden. Welcome, Rachel. It's a pleasure to have you.
Thanks so much, Jen. I appreciate you having me and getting to learn from people whose footsteps I'm following in.
Bit about your background in the law. Your parents are both lawyers, correct? And both lawyers for the military. Did that influence your decision to go into law or your attitude towards the law at all?
I would say that it de-influenced me from going into the law for a very long time. And it certainly shapes my attitudes to the law. Because while my parents and I don't agree on everything in terms of the state of the country, the law, the path forward, we do agree on the American experiment as one that has so much potential when we operate in a way that is building systems that work. And so I think that their bravery and service is something that always informs my approach to the world and to the law broadly.
Interesting. So there have been many developments of late vis-a-vis the White House and law firms. Covington was first targeted, and shortly after that, Perkins and Coy. When did you first become alarmed that this might not be just a one-shot deal and that there might be a sort of epidemic of these?
Reading the Perkins executive order. The first step in a lot of the organizing that I and many of my friends and newfound friends have been working on was to get people to read that executive order all the way through. Because as I'm sure you know, it's a huge part of the Trump administration's kind of shock and awe campaign to blanket us with executive orders and kind of guidance that it's impossible to consume all of it and to parse through what matters. And so I actually hadn't read the Perkins executive order all the way through until some group texts were extremely perturbed. And then I did, and I realized why they were extremely perturbed, and particularly paired with the president's PSLF, or Public Service Loan Forgiveness executive order, the following day. They're laying it all out for us, but you have to have time to read it. So the Perkins executive order contained clear directives to escalate this kind of attack on other law firms. And the PSLF executive order the following day outlined what areas of practice and representation were most likely to be at risk. And they included things like access to immigration representation, making sure that people have access to gender-affirming care, voting rights, and free speech. It was horrifying, frankly.
And what did you do at that point?
So I have friends across the globe, and I tried to go to sleep at 11 to get 8 hours, which is pretty rare for any third-year associate at a large corporate law firm. And every 10 seconds, I would think of a different implication of the executive order that I had just read and become certain that I was misremembering what I had read and pull my phone out and reread it and realize it was in fact even worse than I had thought. And then I would text a friend on the West Coast, since it was 3 hours earlier, and say that to them. And then I repeated that cycle until my West Coast friends went to bed and my friends in London had woken up. And at that point, there was a significant draft of our open letter put together. And I went to sleep for a couple of hours and then started reaching out to people on Eastern time to make sure that they had read the executive order and to ask some of my most trusted friends to take a look at the draft that I had going and to provide comment and talk through what a longer term organizing strategy could look like.
And what was the purpose of the initial letter? What did you want to accomplish? Just to inform people, or did you want to send out a warning signal to other firms? What was your intention at that point?
My intention was to capture the extreme discomfort that was already felt by the vast majority of attorneys, both inside and outside of large corporate law firms, when they were reading and kind of synthesizing these executive orders. And so there was certainly an element of wishing to inform people because, as stated, we're inundated by information right now. But there was also a deep desire to effectively demonstrate to law firm leaders how uncomfortable their associates were. This is a risk-averse industry. It is an industry where once you are blacklisted, it is very, very hard to get another job within it. And so people are very unwilling to speak up, especially when they think that what they're saying is what law firm leaders don't want to hear. They're not always even sure on how to do that and who to reach out to and who's making the decisions at their law firm. And it seemed like there was a lot of utility in just having something that people could bring with them, saying, look, hundreds of people agree with me on this.
And at what point did you talk to the partners, the more senior associates and so on at Skadden? Did they read it, or did you request a meeting about it? How did those conversations come about?
I reached out to multiple people in leadership at Skadden prior to releasing the open letter, because the open letter was always a plan B. The termination email was a plan, I don't know, AAA, or however far down the list we need to go. My ideal outcome here has always just been for law firms to stand up for the system that they work in. And so the most effective way of doing that is certainly not by jumping to the most confrontational way of doing that. I reached out to, the night the Perkins executive order came out, to a partner that I trusted deeply and asked if there was an industry-wide movement or response being coordinated. And he never responded to me. I reached out to multiple other trusted leaders the following day and received extremely dismissive one-line answers. One of them did offer a meeting, but when I reached out and asked for a time, he stopped responding to me until significantly after I'd started speaking publicly. And so starting the letter that early, I don't want that to be misread as that being our preferred path forward, because our preferred path forward would be to not be in the midst of an ongoing coup that is having to be resisted by some of the people in the big law industry with the least amount of power.
Now, was there a division within Skadden between partners and associates, or between lawyers in, for example, litigation and lawyers in corporate law? There was obviously some difference of opinion. What was the dividing line as far as you saw?
My impression is that there really wasn't that much of a division in opinion in terms of what this means. Something that I do find compelling and that I believe, based off the responses that I got from people in leadership, was that maybe the difference in opinion is on the severity of the moment and how immediately we need to act. Because I think across the board, everyone acknowledges that these are gross oversteps, that they are outside the bounds of the normal, and that they are aimed at undermining rule of law and the court system in this country. But I think that myself and many others view this as not a first step, but an early step towards the Trump administration refusing to leave office in 3.5 years. And I am not sure that law firm leaders are meeting that with the same urgency. And I would like to hope that if they do see it that way, that they are not selling the country out for the sake of a few more billable hours.
And was that division in perception about the seriousness, was that again a factor of years in the law? Was that did opinion differ from department to department? What was your perception of how urgent and which people felt a sense of urgency and which did not?
It seemed to me that there was a strong correlation between thinking that we could ignore this and what your percentage of the profits of the law firm are.
That's very candid of you. Shortly after this, of course, the Paul Weiss, well, first of all, let me back up a minute. Perkins obtained representation from Williams and Connolly, and they sued. Were you at that point gratified that there might be some kind of stance that would be taken not only by Perkins, but by other firms?
Yes, I was unbelievably hopeful. And I think that Perkins is giving a master class along with Williams and Connolly in what the appropriate response to this is. It is unfathomable to me that one of the quote unquote best, I'm questioning that, as I'm sure many other people are right now in terms of instincts and capacity to litigate effectively, that one of the quote unquote best law firms in the country did not follow this path clearly laid out for them, particularly when the Paul Weiss executive order was issued while there was a temporary restraining order issued in the Perkins executive order. It's clear that judges are going to reject these actions because they should, because they're outside the bounds of the law. And so to not fight that, particularly knowing that then instead of uniting behind the path that Perkins has laid out for you fighting the Trump administration, knowing that you are creating another option for law firms to follow.
Now, it appeared that initially Paul Weiss was going to stand up, that they were seeking some kind of counsel, that they were preparing to make a stance. And then it came out that, of course, that they had capitulated. They had a meeting at the White House, and they had signed on to a whole series of measures that really invaded, quite frankly, their own First Amendment rights to choose whatever counsel. And just as Judge Howell had said in the Perkins case, First Amendment, Fifth Amendment, Sixth Amendment potential violations, and yet they settled. Were you surprised by that?
I was shocked.
And in your own mind, can you understand, or have you come to understand what motivated that? Again, they had the example of Perkins and they had an order from Judge Howell, so they could have stood up to the administration. Have you learned anything that would give any insight into why they caved?
So I did actually receive, right before we spoke, a copy of a firm-wide email that Brad Karp sent out today. And I have not had the chance to review it as closely as I would like to. I don't know, and maybe I'm biased, but I think that in the scheme of firm-wide emails over the last couple of days, I'll still back my own. But his pointed to, in part, a failure of the industry to rally behind Paul Weiss as one of the reasons why his hand was forced to make this decision, making it significantly harder for law firms to rally around any other law firm under attack by the Trump administration. And so at the end of the day, I think it has to do with unwillingness to have even an iota of sacrifice for the good of the industry and the country as a whole.
To your point, simultaneous with the Paul Weiss cave, 20 big law firms received very exacting questionnaires about so-called DEI policies, about internal firm management and the rest. And of course, the White House came out with a remarkable executive order, and I use that not in a positive way, but essentially saying that they were going to seek sanctions against lawyers who they didn't really think were behaving properly. They use the word scurrilous. So we're not talking that there was a specific precept of professional ethics that they had violated, and that they were then going to refer these people to the bar. Seeing what happened in this succession of issues, when did you reach the conclusion that you needed to resign, or that you were conditionally resigned from Skadden?
I think that the Paul Weiss decision precipitated my own decision because Skadden is one of the firms that received those EEOC demands. And over the days following that receipt, because those demand letters are public online, and so again, it was kind of a push amongst organizers to make sure that their friends had read them and fully internalized what was going on, and felt empowered to go speak to firm leadership and ask, what are you doing about this? Are you going to sell out your associates or not? And we were getting answers like, well, I haven't had the chance to read it carefully yet, from people in management about a 10-page document, which does not speak particularly well to the quality of representation. And I have to say, in my experience, the quality of representation was quite high. And so what that implied to me instead was that they were lying, and that we would find out, similarly to all of the associates at Paul Weiss, that the decision had been made via front page New York Times article. And so we have a big problem sometimes in organizing with proactivity versus reactivity. I think especially when you might be viewed as alarmist, you don't want to come across crazy. And we wait for the bad thing to happen before we act. But if you act after the bad thing has happened, you can't stop it. And that's what I realized as I was on the bus home from work that day.
What was the reaction within Skadden after Paul Weiss paved? Again, did you see a division between, as you put it, the high earner partners and the rest of the firm? Was the concern more widespread at that point after a firm like Paul Weiss, which had a reputation for support of progressive causes, had capitulated in such a dramatic way?
I have to be honest, I can't really speak to that because I think that the discourse there was largely shaped by the email that I sent, and I have been removed from the system, so I don't know. I do know on an individual level that I have received outreach, not just from many, many associates at Skadden, but across the industry of screenshots of emails that they're sending to their managing partners saying, we will not accept this kind of fold. And I'm hoping and beginning to see the start of organizing that I hope evolves to refuse to recruit for these firms unless they stand up for their associates and for the broader country.
So do you think that Paul Weiss will pay a price for this, that they will lose associates, that they will, I'm going to ask you about that laughter in a minute, that they will lose associates, that they will lose recruits, that they will lose clients? Or do you think they're just going to go merrily on their way and they'll just see this as, a little bump in the road for them?
I think that they will go down as the Neville Chamberlain of the industry and that it will be the worst business decision possibly ever made by a law firm.
Wow. Do you believe that there's going to be an exodus from Paul Weiss, or even a fracture of the law firm in the near future?
I believe that there will be an exodus, but that it will be difficult to tie back to this because I recognize that many people are not positioned as I am to relinquish kind of any future in the corporate law firm world, and presumably many clients as well. And
Yes.
so I think that we're not going to see a lot of firm-wide emails, but I think that that's actually a good thing because, as stated, the goal of this organizing is for it to work, not for people to go viral on LinkedIn. And what is going to be far more effective is a gradual loss of associates to firms that have a backbone, and organizing within the firms to exert pressure on the partnerships to do the right thing, which coincidentally happens to align with the sound business decision and what's legal.
So at this moment, are you still employed by Skadden, or has your employment been severed?
I am off the website, but being paid through the end of my notice period.
Got it. Got it. So taking a step back, is it purely financial concerns? Is it a lack of realism about the extent of the problem that has driven this passivity, this kind of excuse mongering about steps that really impinge, as Judge Howell said, on the First Amendment, on the Fifth Amendment, on the Sixth Amendment, on people's sense of professional ethics? Why has the result so far been so subdued, so diffuse, and frankly, so cowardly?
I think Big Law has a huge collective action problem, which is something that we really tried to remedy in the way that we set up the open letter. That's why signatories were anonymous. We didn't publish it anywhere until we had over 100 of them. You'll notice the first 100 signatories are alphabetized to really go above and beyond in terms of preserving anonymity for people. And it's because we are so risk averse. That's how you become these kind of deeply institutional and important corporate law firms that have existed for now generations. But risk aversion then makes people believe that it is always bad to be a first mover. And the thing is, sometimes it's not just good to be a first mover, but it makes you look really, really smart and sharp. And this job demands contingency planning and being able to predict what is happening based off of the current moment. And so I think that there is a lot of incentive in the long term. Again, we're seeing Perkins hedge these bets and Williams and Connolly hedge these bets. And those are extremely smart attorneys as well. And I think with a lot of certainty that they are right in their handling of this. And I think that we will, not in the immediate future, it's a question of a trade-off of some immediate profits for being the place that got it. And I think that the latter is worth a lot more.
What would help encourage law firms to do the right thing? Is the pressure from clients, from associates, from the public opinion? What do you think is the most important thing for them to help them make the right decision if they don't have the internal wherewithal to initiate that process themselves?
Based off my experience, I think that the most powerful motivator for a big law firm to do something is whether or not everyone else is doing it. And so I'm a little bit heartened. I know, again, right before we got on the phone, I saw that Celindy Gay put a statement out, and they are a boutique, but they're a big name with really great attorneys. And so I think that, and I know a couple of other firms did yesterday as well. And I think that that's really helpful, but I think that you get more firms there primarily through client pressure. Yes. And I know that there are a lot of GCs that are reaching out to their representation right now and saying, where are you guys?
What do you plan on doing now? Are you going to look for another job in law? Are you going to try to continue your advocacy? Are you going to do both? What are you planning over the next weeks and perhaps months?
In the immediate future, I am going to use every ounce of the privilege that I hold across so many different metrics to try and mitigate the harms that are coming out of this administration. And right now, I am frankly overwhelmed and blessed by the number of opportunities that I've been given to be able to do that. Because I think that there's been a lot of utility in sounding the alarm and being willing to speak about it. Because I think that when you say it out loud, everyone knows that it is correct. In the long term, I think it's going to depend on whether or not we have a country.
Well, I think that is no exaggeration. And for all the lawyers out there who may see this, I have to say there is an extreme need for representation for people who are targeted by this administration. Everyone from FBI agents who were concerned that their identities were going to be released publicly and targeted, to immigrants who are now finding themselves in deplorable conditions in other countries. So if you're an associate out there, if you're a lawyer, if you're a partner, there is legal work to be done. And I think what is needed is courage. Rachel, it is an extreme pleasure to have you. And I think you're setting an example not only for lawyers, but for the country at large. This is a time, to quote from the other end of the political spectrum, a time for choosing. And people have to make their stance and make their choice. So thank you for what you are doing. Thank you for speaking to us. And we certainly wish you the best of luck, both in your professional career and in your crusade, because this is what it means to defend democracy. So thank you.
Thank you. And I think even just to pull a quote from the other side of the political spectrum to support speaks to how non-political and instead how existential this moment is. And I'm really grateful for the chance to speak with you and to kind of share my thought process and what's going on with your readers and viewers.
My pleasure. Bye-bye.